Good afternoon. It's great to be back at Westminster Canterbury. My name is Tim O'Rourke. I trust that you're all safe and doing well and finding new pleasures in the midst of the quarantine. This is the second of a four-part series on contemporary political issues under the general theme of something old, something new, something borrowed, something blue. Last week, under the heading of something old, we considered the legacy of Thomas Jefferson and the enduring influence of the Declaration of Independence. Today, I'll be looking at three cases awaiting decision before the Supreme Court of the United States. Next week, I'll look at the looming debt crisis, and the following week, the last of the four parts, I'll consider the level of civility in American society and the capability of Americans to come together to address not only the immediate but the enduring challenges that our nation faces. It's useful to remind ourselves of the four overarching questions that I think these lectures will address, the so-called big questions. And one is how the founders' values continue to shape and influence American society. A second is what is the link or the tension between fair process and just outcomes. A third is whether our democracy can address and solve big problems. And of course, we're exploring that question in the midst of the coronavirus crisis. And finally, can we explore common ground and find common ground through meaningful and civil conversations? And so if last week's lecture focused primarily on the first question, today's lecture is really partly about the first question and primarily about the second, the link or tension between fair process and just outcomes. And so the focus is on something new. And the Supreme Court has heard oral arguments in three cases that concern sexual orientation and transgender rights under federal employment law. And it's interesting, when I came to Westminster Canterbury last fall, I touched briefly on these three cases, but only briefly, and I thought they merited additional attention. And having now spent some weeks reading briefs in these cases and thinking about these cases, I think my sense that these are extraordinarily important cases will be vindicated, and I hope after you hear my extended treatment of them that you'll agree. The cases are really about the court, the Congress, the Constitution, and the people, and the intersection of these four elements. And before I go further, I wanted to draw your attention again to one of my favorite, if most unsettling, polling results. Americans were asked to identify the three branches of government. And as you can see from the slide, a third of Americans did not know any of the three branches, and only a fourth could name all three branches. It's a somewhat discouraging portrait of the level of civic understanding, and it's a perhaps troublesome predicate for what we want to talk about today, which is the relationship between the Congress and the court in the making of laws. I thought it might be appropriate to start at the beginning with the Constitution. And the Constitution provides in Article 1, Section 1, that all legislative powers herein granted shall be vested in a Congress. In other words, we expect that the Congress will make the laws. On the other hand, Article 3 provides the judicial power shall be vested in one Supreme Court, and the judicial power shall extend to all cases in law and equity arising under the Constitution, the laws, and the treaties made under that authority. In the Federalist Papers, Alexander Hamilton had occasion to comment on the role of the courts in the constitutional system. And famously, he said in Federalist 78 that the judiciary will be the least dangerous branch. But he also said in that same paper that the interpretation of the laws is the proper and peculiar province of the courts. And so what we really expect is in the plainest presentation of the Constitution is that the Congress will make the laws, the Supreme Court will interpret them and apply them, and the executive branch will enforce the laws. In Federalist 81, Hamilton considered the question of what would happen if the court drifted into the business of making laws. And he said this: it may, in the last place, be observed that the supposed danger of judiciary encroachments on the legislative authority is in reality a phantom. Particular misconstructions and contraventions of the will of the legislature may now and then happen, but they can never be so extensive as to amount to an inconvenience. This may be inferred with certainty from the general nature of the judicial power, from the objects to which it relates, from the manner in which it is exercised, from its comparative weakness, and from its total incapacity to support its usurpations by force. And essentially what Hamilton was pointing out here is that judicial decisions depend on the executive for enforcement, that Congress can always revise laws that the court has misinterpreted, and ultimately the Congress has it within its power to remove justices or judges who serve for life or good behavior. And so thus we have the classic characterization, again, the Congress, or the court rather, as the least dangerous branch. Before I go further, I wanted to remind you of the wonderful internet sources available on the Supreme Court of the United States. One is offered through the Legal Information Institute, Cornell Law School, Justia, the Chicago Kent School of Law, and it's called OYE, oye.org. And this presents information on the court's current docket, provides oral transcripts, and you can listen to oral arguments before the court. The website also provides background information, very useful summaries of each case now before the court, and goes back some years in providing information on earlier cases. The Supreme Court's own website, which shows on the screen, is also a terrific source. And you can go to the court's website under the docket heading and read the briefs that have been filed in the various cases. You can also listen to the oral arguments and read the transcripts of those oral arguments. And the value of the OYE site, in contrast to the formal official site of the Supreme Court, is that when you listen to the oral arguments at OYE, the judge's faces pop up, and that doesn't happen at the Supreme Court site. But these sites are both very useful, and I find them to be endlessly fascinating and very accessible form of government transparency, and it helps you understand the court and the government in general more effectively. I might say a word about how the court does its business. And you see the big number 4 on the screen, which points to the so-called rule of 4. People say, how does the court decide which cases to take? And the short of it is that if 4 justices agree to hear a case, the court will hear the case. The interesting thing about the number 4, of course, is 4 is not 5. And in a typical case, it takes 5 of the 9 justices to decide a case one way or the other. When is the Supreme Court likely to take a case for what is called plenary review, hearing oral arguments? And there are a number of factors, but one is if there is a difference in the holdings of the various circuit courts of appeals. Second is if a law has been ruled by the lower courts to be unconstitutional. Third factor is whether the United States is a party. A fourth factor is whether it's an evolving area of law in which the court is interested. And a fifth factor relates to amicus curiae filings. Amicus curiae, Latin for friend of the court. And the amicus filings are extended at the approval of the court by various interest groups that have an interest in the outcome of particular case. And I have a lot more to say about this as we proceed through the material today. You know, it's a common cliche that if somebody loses a trial court, a lawyer will say, well, we're going to fight this all the way to the Supreme Court. That's more the stuff of television drama than reality. If we go to the third element of the slide with regard to the cramped docket, about 9,000 cases are appealed to the Supreme Court every year. But in point of fact, the Supreme Court only discusses about 10% of those 9,000 cases. And even the cases that make it to the discuss list only get about 6 minutes of conversation among the justices in conference. In the end, the court hears oral arguments in only about 80 cases per year. And in a typical oral argument, each side of the dispute is accorded a half an hour. And after the court hears oral arguments, it typically votes in conference, and then over succeeding weeks or months, then works out the opinions that will be issued in the case. So I think a lesson from this, the big number four to take a case for oral argument, and that only a small number of cases that arrive in the court's docket, about 80 per year, will be the subject of full-blown oral arguments. In the cases at issue in today's talk, the focus is a statute. And the statute in question is the Civil Rights Act of 1964, specifically Title VII. And Title VII provides in part that it shall be unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. And then the following section goes on to elaborate on that with respect to the same categories: race, color, religion, sex, or national origin. And so the question in play in the three cases we'll be talking about is whether sex under Title VII covers sexual orientation and transgender status, or what is also called gender identity. Interesting thing about the language of Title VII is that the inclusion of sex was not part of the legislation reported out of committee. The amendment that added sex to Title VII came from Howard Smith, who was a Virginia congressman, chaired the House Rules Committee, was a segregationist, and there's some question about his intent in offering this amendment, but it was widely supported, and it certainly played an important role in achieving fairness in the workplace for men and women. So, starting in 1964, the court has been called to interpret the meaning of the prohibition against discrimination on account of sex in the Civil Rights Act 1964. And as I've suggested, the court has worked with a very flimsy legislative history and the lean language of Title VII itself. But let me point to three cases among many that give some idea of the evolution of the prohibition against discrimination on account of sex in Title VII. One case is Meritor Savings Bank versus Vincent. And in this case, the Supreme Court said, and I'm quoting from Chief Justice Rehnquist, the language of Title VII is not limited to economic or tangible discrimination. The phrase terms, conditions, or privileges of employment evinces a congressional intent to strike at the entire spectrum of disparate treatment of men and women in employment. Second case came before the court in 1989, Price Waterhouse versus Hopkins. It's an interesting case because a woman who worked for the Price Waterhouse firm was denied promotion to partnership because, in the view of the partners and in the finding of the court, she was not appropriately feminine. She was aggressive in her manner, did not dress in a what her prospective partners described in a feminine way. She swore, but she was otherwise highly successful in her position. And the Supreme Court found that sexual stereotyping of the kind that denied Hopkins her promotion to partner was a kind of discrimination that properly fell within Title VII. Quoting Justice Brennan, who wrote the plurality opinion for the court, it takes no special training to discern sex stereotyping in a description of an aggressive female as requiring, and a course in charm school, that language came from one of the partners, nor does it require expertise in psychology to know that if an employee's flawed interpersonal skills can be corrected by a soft-hued suit or a new shade of lipstick, perhaps it is an employee's sex and not her interpersonal skills that has drawn the criticism. And finally, in the case of O'Calley versus Sundowner Offshore Services, this dispute involved male-on-male sexual harassment on an oil rig. And Justice Scalia wrote for a unanimous court in this case, and he said, and here again it's quoted, as some courts have observed, male-on-male sexual harassment in the workplace was assuredly not the principal evil Congress was concerned with when it enacted Title VII. But statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils, and it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. And so these three cases, which are an important selection of the cases that have raised sexual discrimination claims under Title VII, it's clear that the meaning of Title VII has evolved over time, that the court has put skin and bones, or skin and muscle, on the bones of a leanly written statute. And this brings us to the three cases that were argued before the court last October and are awaiting decision. Two cases involved the application of Title VII to sexual orientation: Altitude Express versus Zarda, Bostock versus Clayton County. And the question presented in oral argument, whether the prohibition in Title VII against employment discrimination because of sex encompasses discrimination based on an individual's sexual orientation. And in both of these cases, gay men were the subject of adverse employment decisions. They were fired by their respective employers, and they asserted that the firing was discrimination on account of sexual orientation. The third case raises the question of whether sexual discrimination under Title VII applies to somebody who is in transgender status. In this case, Harris Funeral Homes versus EEOC, and Amy Stevens raises this issue, whether Title VII prohibits discrimination against transgender people based on their status as transgender or sex stereotyping under Price Waterhouse versus Hopkins. to kind of cut to the chase before digging into the details, there are two ways of approaching these cases. And one way is to ask the question, does sex under Title VII prohibit discrimination on account of sexual orientation or gender identity? And the answer might be no. This is a matter for Congress because the law in question dates to 1964, at which point there was no indication that Congress had sexual orientation or transgender status in mind. Alternatively, one could say, is discrimination on account of sexual orientation or gender identity a form of sex stereotyping? And following that logic, the answer would be yes. The court has already addressed this as a Title VII issue in the Price Waterhouse case, and the meaning of Title VII is not precisely fixed to what Congress might have had in mind in 1964. Let's consider the case of Bostock in Clayton County and briefly go through the facts to lay the foundation for further discussion of this case. Starting in 2003, Bostock was a child welfare services coordinator in Clayton County, Georgia, and in that role, he directed the court-appointed Special Advocates Program, a consequential program that provided guardian ad litem representatives to juveniles in the Clayton County courts. And in that role, apparently Bostock performed quite well and was given good annual reviews and achieved some prominence in national organizations. In early 2013, he began playing in a gay softball league in the Atlanta area. That seemed to attract the attention of some Clayton County officials, and not long thereafter, the program that he supervised, the Advocates Program, was subjected to an audit. The county subsequently terminated Bostock for, quote, conduct unbecoming, and in my reading of the record, the relationship between the audit and the dismissal is unclear. And in any event, Bostock asserts that he was fired because he's gay. Federal District Court dismissed Bostock's Title VII claim, and the 11th Circuit Court of Appeals affirmed dismissal on the grounds that Title VII doesn't cover discrimination on the basis of sexual orientation. And so Bostock's claim, simply put, is discrimination on account of sexual discrimination is discrimination on account of sex within the meaning of Title VII. To expand on this, Bostock argues that the plain language of Title VII requires the conclusion that sexual orientation discrimination is discrimination because of sex, that his claim fits squarely within the text of Title VII. He further argues that employer must view employee's sex in order to judge sexual orientation, that discrimination on the basis of sexual orientation is impermissible associational discrimination, analogous to the discrimination against miscegenation that Supreme Court declared unconstitutional in the famous case of Loving versus Virginia. Bostock also argues that sexual orientation discrimination is stereotyping within the meaning of Price Waterhouse. The stereotype is that men should be attracted to women. If men are attracted to men, they're not behaving in the expected way and are therefore subject to discrimination, much as the woman in Price Waterhouse was subject to an adverse employment decision because she didn't behave according to the appropriate stereotype. The language of Nkali suggests that Title VII should be read expansively and that sex under Title VII should encompass sexual orientation. Bostock goes on to argue in his brief that the history of Title VII confirms that it covers sexual orientation, and he cites Uncali and Meritor Price Waterhouse, and that Congress has, by not acting to overturn these cases, has implicitly accepted these changes. And at the same time, the fact that Congress has not added sexual orientation to the language of Title VII can't be read as excluding sexual orientation, because in Bostock's argument, you can't infer congressional opposition to sexual orientation from its inactivity. I thought this would loom larger in the brief. It turns out in a footnote that Bostock argues that excluding sexual orientation from Title VII would be inconsistent with the court's treatment of sexual orientation in a succession of cases, including Obergefell v. Hodges, the gay marriage case. And so as the Supreme Court has struck down laws that burden gay and lesbian people, most prominently in the gay marriage case, it seems anomalous that Title VII would not extend to sexual orientation. But these cases, the gay marriage case was not decided on the basis of sex discrimination, and it was a constitutional case, and so this is a statutory controversy, and so the application is not the application of the gay marriage case is not direct. And as I said, it found its way into a footnote rather than being a leading argument in the case. In any event, Bostock contends it's impossible to distinguish between sex stereotyping and sexual orientation, and that maintaining the distinction would leave the lower courts adrift and confused in applying the law. Clayton County's reply goes something like this, and I'm quoting: "When Congress prohibited sex discrimination in employment 55 years ago, it did not simultaneously prohibit discrimination on the basis of sexual orientation. During the past 45 years, on more than 50 occasions, Congress has rejected proposed bills to amend Title VII to encompass sexual orientation. Amending Title VII is the sole province of Congress." And this is the core of the argument for, not only for Clayton County, but as you'll see, for the United States position expressed through the Solicitor General. That is to say, the amendment of the law is a topic for Congress, not one for the court. Clayton goes on to say, sex and sexual orientation are separate and distinct concepts, and employment decisions based on sexual orientation do not treat employees of one sex more favorably than similarly situated employees of the other sex. The argument goes on to suggest, and this borrows language from famous language from Justice Scalia, Congress does not hide elephants in mouse holes. In other words, if Congress had thought that sex covered sexual orientation, it would have made that manifest in the express terms of the law. It didn't do that. So that sex in 1964 did not mean sexual orientation. Until 2017, Clayton County points out, no circuit court had held sex to mean sexual orientation. And so this is a novel view of the law. It is, as the theme of today's talk would suggest, something new. Congress rejected an amendment to the Civil Rights Act of 1991 that actually called for interpreting civil rights statutes broadly. And in the view of Clayton County, if an employer treats a gay employee and a lesbian employee the same way, that is to say, subject to firing, the employer does not discriminate. And then the court, according to Clayton, that is, the Supreme Court has not treated sexual orientation cases as examples of sexual orientation discrimination. And the civil rights, Clayton argues that the Civil Rights Act of 1991 implicitly adopted the views of the lower courts and the EEOC up to that point in time, rejecting incorporating sexual orientation into Title VII. There is a bill pending before Congress that has passed House of Representatives, the Equality Act of 2019, that would amend Title VII to add sexual orientation, but that's a bill that is pending and is not passed. But it would be Clayton's argument that this is a matter for Congress ultimately to decide, not a matter for the court. Finally, Clayton County argues that an employer who opposes homosexuality is not disadvantaging either sex, and it isn't stereotyping unless the stereotype attaches either to men or to women. The second case involving sexual orientation raises much the same question, and except that it arises in the context of a private employer as opposed to a public employer such as Clayton County. And in the interest of time, I'll skip to the question arising under the Harris Funeral Homes case, which involves transgender status or gender identity. And the facts in this case go like this. Tom Rost is a self-described devout Christian who owns Harris Funeral Homes based in Michigan. It's a family business. One of his employees, Anthony Stevens, now Amy Stevens, served as a funeral director, compiling a somewhat uneven work history. In 2013, after 6 years, Stevens told Rost that Stevens was transitioning and would be assuming status as a woman and would begin dressing as a woman. The funeral homes has a, quote, sex-specific dress code based on biological sex. Ross believed that Stevens's transition would prove problematic for the business in terms of the dress code, bathroom facilities, and interaction with clients processing their grief. Ross fired Stevens, who then filed a complaint with the Equal Employment Opportunity Commission, which sued Harris Funeral Homes to block the firing. District Court dismissed this transgender status claim, but allowed the suit to proceed as a stereotyping claim before ruling in favor of Harris on a religious freedom claim. On appeal, the Sixth Circuit Court of Appeals reversed, holding for the Equal Employment Opportunity Commission, that is for Amy Stevens, on both the transgender status and stereotyping claims, and rejecting Harris's religious freedom defense. The position of the EEOC had been dictated by the Obama administration, and the Trump administration reversed the EEOC's position. And so the EEOC, which at one point was supporting Amy Stevens's claim, is now supporting Harris's funeral home appeal to the Supreme Court. And Harris's claim essentially is federal courts should not usurp Congress's authority by judicially amending Title VII. Quote, redefining sex discrimination will cause problems in employment law, reduce bodily privacy protections for everyone, and erode equal opportunities for women and girls. Congress, not the courts, is the institution best positioned to balance those considerations. Stevens' brief in the Harris case includes these arguments. As the Court of Appeals recognized, Harris Homes fired Amy Stevens without ever discussing the dress code because she is transgender, and departed from its owner's sex stereotypes about how men and women should appear, behave, and identify. The hallmark of Title VII's protections is that an individual employee should be judged on merit and not sex. Whether a given course of conduct constitutes sex discrimination under Title VII is not determined by what members of Congress envisioned in 1964 1978 or 1991, but on the text of the statute. This court has recognized that discrimination because of sex encompasses different sex sexual harassment, same-sex sexual harassment, and partial reliance on sex stereotypes in promotion. This is a reference to that sequence of cases to which I referred earlier. In such cases, the court was governed not by an assessment of Congress's imagination, by what Congress might have had in mind or not in 1964, but by the text it enacted. This case does not require the court to redefine sex or to declare invalid all sex distinctions in the workplace. A ruling for Ms. Stevens would have no necessary implications for how schools, athletic associations, and family law integrate transgender people. And this is a reference to the claim from Harris that a ruling that transgender people are protected under Title VII would cause all manner of disruption in the workplace. Stevens argues otherwise. And in the oral arguments, Justice Breyer referred to this argument that a decision in favor of Stevens would be highly disruptive as the parade of horribles argument. As I mentioned, the United States government switched positions on this case, and the Solicitor General, who speaks for the government before the Supreme Court, filed a brief in which he says that in 1964, the ordinary public meaning of sex was biological sex. It did not encompass transgender status. He goes on to say that the Sixth Circuit Court of Appeals, which ruled on the Stevens case, held that transgender status discrimination constitutes discrimination on the basis of sex, but treating all transgender persons less favorably than non-transgender persons does not violate that rule. The Sixth Circuit's approach would invalidate all sex-specific policy from restrooms to dress codes. A transgender plaintiff therefore cannot prevail in a Title VII suit simply by showing that an employer relied on sex stereotypes. And this important element in the Solicitor General's brief. To be clear, the question in this case is not whether employers ought to be prohibited from discriminating against individuals who are transgender. It is whether Title VII, as written, currently bars such discrimination, and whether Title VII should reflect societal changes that Congress in 1964 could not have envisioned. Fundamentally, however, that is a question for Congress, not the courts. So here we are again, back to the Congress versus courts argument. Now, in kind of sorting out this, I found guidance from a recent book by Neil Gorsuch, who is a relatively new member of the Supreme Court. The title of the book, A Republic If You Can Keep It. And in this book, Gorsuch devotes a chapter to the subject of how the judges or justices can interpret a statute. And he offers three potential guides. One is textualism, which in his words tasks judges with discerning only what an ordinary English speaker familiar with the law's usages would have understood the statutory text to mean at the time of its enactment. A view that seemingly would favor the position articulated by the Solicitor General, but bear with me. Purposivism, which gives primacy to the perceived spirit of a statute to further its primary purpose, even at the expense of the letter of the law. And then what he calls consequentialism, which seeks to select the outcome calculated to produce optimal policy results along with some metric, regardless what those in Congress might have intended. Gorsuch fancies himself as a textualist, and a view that was to which Justice Scalia also subscribed. And I have pulled some elements from the oral arguments in these cases. The Bostock and the Altitude cases were the subject of 1 hour of oral argument, and the Stevens case was the subject of a separate hour of oral argument. But here's an example of how textualism figured in the oral argument in the Bostock case. And this is from Justice Kagan. She says, for many years, the lodestar of this court's statutory interpretation has been the text of a statute, not the legislative history, and certainly not the subsequent legislative history. And the text of the statute appears to be pretty firmly in Ms. Carlin's corner. Ms. Carlin is the attorney representing Bostock. Did you discriminate against somebody, against her client, because of sex? Yes, you did, because you fired the person because this was a man who loved other men. If he were a woman, he wouldn't have been fired. This is the usual kind of way in which we interpret statutes now. We look to laws. We don't look to predictions. We don't look to desires. We don't look to wishes. We look to laws. Why doesn't that mean your argument failed? So this is a question Kagan addressed to the Solicitor General, Noel Francisco, and this is a question addressed to the Solicitor General, but seemingly addressed to her colleague, Justice Gorsuch, because she is adopting a textualist argument and saying on that basis, Bostock and Stevens should prevail. The Solicitor General responds, well, because, Your Honor, I think what our brief attempts to do is make a straightforward textual argument. The law distinguishes between sex and sexual orientation. Here's an exchange in the Harris Funeral Homes case between Justice Gorsuch and the attorney representing Amy Stevens. And this is important, Justice Gorsuch says, I'm with you on the textual evidence. It's close. We're not talking about extra textual stuff. We're talking about the text. It's close. At the end of the day, however, should a judge take into consideration the massive social upheaval that would be entailed in such a decision and the possibility that it's more appropriate a legislative rather than a judicial function? That's it. It's a question of judicial modesty. And so here we have, in posing this question, Justice Gorsuch, the textualist, is saying, see, I don't know. I think it is a close case on whether the text favors incorporating sexual orientation and transgender status. Mr. Cole for Amy Stevens has said, well, first of all, federal courts of appeals have been recognizing discrimination against transgender people as sex discrimination for 20 years. There's been no upheaval. And he goes on to say, as I was saying, there are transgender male lawyers in this courtroom following the male dress code and going to the men's room, and the court's dress code and sex-segregated restrooms have not fallen. And essentially, he goes on to say that a ruling in behalf of sexual orientation and transgender status would not have the havoc that Harris and Clayton County suggest. He concludes there's no textual basis for drawing the distinction between sex and sexual orientation discrimination. And that's because our argument rests on text meaning, at a minimum, sex assigned at birth or biological sex. Here's a kind of example of purposivism in the Harris Funeral Homes oral argument. This is Justice Ginsburg. No one ever thought sexual harassment was encompassed by discrimination on the basis of sex back in '64. It wasn't until a book was written in the middle 70s bringing that out. And now we say, of course, harassing someone, subjecting her to terms and conditions of employment she would not encounter if she were male, that is sex discrimination. But it wasn't recognized to be such in the beginning. And so she's looking to the spirit of the law and what it means to prohibit discrimination on account of sex. Justice Sotomayor, in my view, comes a little closer to consequentialism, which means what is good public policy? And she says, may I just ask, at what point does a court continue to permit invidious discrimination against groups that, where we have a difference of opinion, we believe the language of the statute is clear? I think Justice Breyer was right that Title VII, the Civil Rights Act, all of our acts were born from the desire to ensure that we treated people equally and not on the basis of invidious discrimination. And I won't read the entire quote, but she concludes, at what point does a court say Congress spoke about this. The original Congress who wrote this statute told us what they meant. They used clear words, and regardless of what others may have thought over time, it's very clear that what's happening fits those words. At what point do we say we went, which is to say we, the court, have to step in? And so this, I think, represents a view of consequentialism. What's good public policy? And that perhaps should guide the court. Well, where is the court likely to land? And there are three possibilities. Title VII covers neither sexual orientation nor gender identity, which happens to be now the view of the Solicitor General. Title VII covers both sexual orientation and gender identity, and so Bostock and Zarda and Stevens would prevail on their claims. Then a third possibility is Title VII covers sexual orientation, but not gender identity. I'm not sure how the court would arrive at that distinction, except that the gender identity issue is a little newer and perhaps less obviously a matter for the court to find under Title VII. So, three possibilities. What's another way of looking at these possibilities? Some years ago, Nathan Glaser, prominent 20th century sociologist, wrote an article called Towards an Imperial Judiciary. It was on the occasion of, it was written in 1976, on the occasion of the 200th anniversary of the American Revolution. And Glaser worried about the growing power of the Supreme Court, and he suggested that there were forces at work that were likely to lead to an enlargement of the role of the court in the constitutional system. And he gave three factors that pushed the court in this direction. The first is the court must work out the logic of positions once taken, and it cannot easily withdraw from the implications of these positions. And if you go back to the earlier slide, where you see that the court in interpreting Title VII applied it to sexual harassment, to same-sex harassment, to sexual stereotyping, you can see how it logically, one case logically follows another, and how the gay men and the transgender woman in this case can build on that logic to make a compelling argument before the court. Not necessarily. The second factor Glaser pointed to is the second factor that sustains the permanent activism of the court is the enormous increase in the reach of government itself. And so as government expands into areas such as employment law, among others, the court is called upon to interpret the meaning of the law and inevitably called upon to address consequential issues. And finally, Glaser said the courts will not be allowed to withdraw from the broadened positions they have seized or have been forced to move into because of the creation of new and powerful interests, chief among them the public advocacy law centers. And to reconsider these 3 points, on the logic, you can see how the court decisions have elaborated on the meaning of sex under Title VII. How the creation of Title VII itself is emblematic of the dramatic growth of civil rights law in particular, and of the government more generally, and we'll consider this next week with regard to the debt problem. But the third factor is to my mind most telling, that there are new and powerful interests that have a vested concern in the work of the court. These 3 cases attracted more than 80 amicus briefs, and I've pulled some of them out. So the you can see on the briefs of civil rights groups, and this is just a selection, the brief of the GLBTQ legal advocates and defenders of the National Center for Lesbian Rights filed an amicus brief. The Lawyers Committee for Civil Rights Under Law filed an amicus brief. Employment discrimination law scholars filed an amicus brief, and these are a selection. Medical interests filed briefs in these cases. The American Medical Association and others filed a brief. The American Psychological Association, American Psychiatric Association, and others joined in a brief. And noted doctor studies transgender people. Paul McHugh filed a brief. The American Medical Association, the Psychological Association filed their briefs on behalf of the employees. McHugh on behalf of the employer in the Harris case. Religious groups filed briefs. And so you can see that on the left, the Muslim Bar Association of New York filed a brief. The Conference of Catholic Bishops, joined by other religious groups, including Southern Baptists, filed a brief on behalf of the employers in the Harris case, whereas the Episcopal Church, the United Synagogue of Conservative Judaism, and other religious groups filed a brief on behalf of employees. And so, and finally, business interests filed briefs. There were educational and political interests. The NEA filed a brief on behalf of employees, whereas William Bennett, former Secretary of Education, filed a brief on behalf of Harris in the transgender case. And so these many briefs reflect the sweeping interests of many different people and groups on behalf of the court's decision. Most of the briefs filed in favor of the employees. And that brings us back to Hamilton on the power of the judiciary, suggesting that the judiciary is the least dangerous branch, and that there's certainly elements in or powers within the Congress and the presidency that can constrain the power of the judiciary. But I think the question to raise is whether Congress minds handing off the responsibility. In other words, if the court steps in and decides these cases, and amends Title VII, would Congress regard this as an intrusion into its appropriate lawmaking authority, or would Congress, in essence, be grateful that the court had taken an important public policy question off its hands? On the other side, one can ask, should the court take from Congress the responsibility of making the law? And one can ask, the more, if the court does this frequently, will Congress essentially shirk its appropriate duty? These cases raise that question. So it's a process question. What does the Constitution require? Who should decide? And that, on the other side, raises the question, what's a just result here? And this brings us back to one of my original big four questions. Is there a tension between kind of the formal constitutional process, who makes the law, who is assigned the lawmaking responsibility under the Constitution, but what is the right outcome in these cases? And so my job is not finally to answer those questions for you, but to leave you with those questions to roll around in your mind, make your own decision. I look forward to seeing you next week. Again, stay well and healthy. It's been great to be with you today. And I might mention before I go that starting in May, the Supreme Court is going to be conducting oral arguments just as we're handling our our sessions at Westminster Canterbury. The court is going to convene as a court remotely and have the lawyers make their presentations online. So we're acting just like the Supreme Court today. And so think how you decide these cases if you were one of the justices. Thank you very much. Have a great week.